First, access to equity capital. Funds raised from the initial issue of securities are available to expand operation, increase working capital, or reduce borrowing. The establishment of a market for the company's securities and a shareholder base generally enhance its capacity for further equity capital raising in order to satisfy its funding requirement without increasing its debt funding. Secondary market for shares. The facility to resell shares on the secondary market is an attractive feature to shareholders who know they can readily sell their shares at a price determined by the market. The value of a listed company shares tend to be enhanced by their liquidity and marketability. Third, heightened corporate image. This can be important for companies, particularly consumer sales-oriented companies, as it will ultimately help stimulate growth in the company and attract new business. A public listed company is generally regarded as having a higher standing than a private company and in a better position to expand overseas as it more recognition. Next, attract key employees. A listed company may be in a better position to attract and retain key personnel and other staff by offering shares as remuneration. First, dilution of control. Depending on the extent of the dilution, there is the possibility of an increasing risk of takeover. Second, increased responsibility of directors. Directors of a public company assume additional responsibility and legally obligated to act in the best interest of shareholders. Third, disclosure requirements. Disclosure requirements for public companies have increased in recent years, and this trend will no doubt continue. Some companies fear that disclosing financial information may place them at a competitive disadvantage. Next is cost. There are explicit costs associated with a flotation, both terms of time and money. The initial cost of conversion to a public limited company, the cost of issuing a prospectus, underwriting fees and brokerage, professional advisory fees, accounting and legal fees, and other continuing expenses. Next, insider trading legislation. It has significant implications for directors and principal officers with companies who may wish to deal in the company's securities. To avoid possible legal action for dealing in the shares of the company based on privileged information. Last, less control over the company's direction. Certain transactions to be carried out by the company may be subject to a vote of shareholders. If the controlling shareholders are interested in the transaction, they may not be able to ensure the proper transaction is implemented. Flotation or an initial public offering usually involves the issues of securities to the public at large that are subsequently listed on the stock exchange for the first time. This is known as an issue in the primary market. It is the official listing and quotation of securities for trading by the public on the stock exchange known as the secondary market, which completes the process of flotation. As indicated earlier in this guide, the securities of an established company are usually listed on the main market of Bursa Malaysia Security Berhad. As an alternative, Bursa Malaysia Securities Berhad offers the sponsor-driven ACE market, which allows all companies regardless of size and economic sector to raise capital. To float the securities of a company on Bursa Malaysia Securities Berhad, the company must meet the various requirements of the SC as set out in its equity guideline and must comply with the listing requirements of Bursa Malaysia Securities Berhad. As a general rule, as part of its listing scheme, the company is required to undertake an offering of securities to the general public so that at least a certain percentage of the issued and paid up capital will be in the hands of the public. This is designed to ensure that there will be sufficient shares available in the market to form a satisfactory basis for trading.
The role of the SE. The equity guidelines were formulated to ensure a fair and consistent application of policies. The requirements represent the minimum standards that have to be met by applicants embarking on proposals. The following corporate proposals are issues and offerings of equity securities. Second is listing of corporations and quotation of securities on the main market of the Bursa Malaysia Securities Berhad. And last but not least, proposals which result in significant change in the business direction or policy of corporations listed on the main market. Equity guidelines. The principles on which these guidelines are based embrace the interests of listed corporations, the provision of investor protection and maintenance of investor confidence, as well as the need to protect the reputation and integrity of the capital market. The principles include the following. First, issuers must be suitable for listing and have minimum standard of quality, size, operation, and management experience and expertise. Secondly, issuers and their advisor must make timely disclosure of material information and ensure the accuracy and completeness of such information to enable investors to make an informed assessment of the issuer, the proposals, and the securities being offered. Thirdly, issuers and the directors, officers, and advisors must maintain the highest standard of corporation governance, integrity, accountability, and responsibility. Fourthly, directors on issuer must act in the interest of shareholders as a whole, particularly when a related party has material interest in a transaction entered into by the issuer. Fifth, all holders of securities must be treated fairly and equitably and must be consulted on matters of significance. Lastly, proposals undertaken by issuers must not undermine public interest. Decisions on proposals. In considering the application on proposals for the offering and issue of securities by a public company, the SC may approve the proposal subject to such terms and conditions as it deems fit, approve the proposal with revisions and subject to such items and conditions which the SC deems fit, and reject the proposal. Failure to comply. The failure to comply with the equity guidelines is considered a breach and shall subject a person to the penalties set out under S.354 of the CMSA. Public companies, promoters, and directors of public companies, as well as advisors, reporting accountants, and experts must comply with the various guidelines applicable to them. What are the listing requirements of the Bursa Malaysia Securities Berhad? The listing requirements of Bursa Malaysia Securities Berhad are based on the following general principles. First, all applicants will be of a certain quality and have a record of operations of adequate duration. Second, investors and public will be kept fully informed by the listed insurers of all facts of information that might affect their interests. Third, directors, officers, and advisors of listed issuer will maintain the highest standards of integrity, accountability, corporate governance, and responsibility. And lastly, directors of listed issuer will act in the interest of the corporation as whole, particularly where the public represent only a minority of the shareholders or where directors or major shareholders have material interest in transaction entered into by the listed issuer. Requirements for initial public offerings of securities with listing and quotation on Bursa Malaysia Securities Berhad. Main market. The equity guidelines set out the requirements to be met by public company intending to undertake offering of securities with listing and quotation on the main market of Bursa Malaysia Securities Berhad. There are three alternative routes available for listing on the main market of Bursa Malaysia Securities Berhad. First, profit test. Second, market capitalization test. And third, infrastructure project operation test. Moratorium on disposal of shares pursuant to an initial public offering. This requirement is deemed necessary to ensure the promoters who invariably are in control to dictate the fortunes of the company continue to manage the public company after listing. For listing under the profit test or market capitalization test or infrastructure project operation test, the promoters are not allowed to sell, transfer, or assign their entire shareholdings in the applicant for a period of 6 months of their data listing. Special Purpose Acquisition Company. In assessing the suitability for listing of an SPSC, the SC will take into consideration, among others, the following factors. First, experience and track record of the management team. Second, nature and extent of the management team's compensation. Third, extent of the management team's ownership in the SPSC. Fourth, amount of time permitted for completion of the qualifying acquisition prior to the mandatory dissolution of the SPSC. Fifth, percentage of amount held in the trust account that must be represented by the fair market value of the qualifying acquisitions. And lastly, percentage of proceeds from the initial public offering that is placed in the trust account. Acquisitions resulting in significant change in the business direction or policy of a listed corporation, reverse takeovers, and backdoor listing. The SC will treat a listed company undertaking such proposal as if it were a new listing application, and their proposal would have to comply with either the profit test or the infrastructure corporation test. Secondary listings and cross listings. A foreign company seeking a secondary listing on Bursa Malaysia Securities Berhad and Malaysian incorporated company seeking cross-listing on foreign stock markets are required to obtain the SE's approval. In assessing secondary listing proposals, the SE would look to the standard in relation to corporate governance, shareholders, and minority interest protection and regulation of takeover and merger of the jurisdiction in which the company is incorporated. In the case of cross-listings, the SE will have to satisfy the listing will benefit the company and that the foreign stock market where the cross-listing is sought is a member of the World Federation of Exchange and must be based in jurisdiction that is subject to corporation laws and have standards at least equivalent to Malaysia, particularly in relation to corporate governance, shareholders, and minority interest protection, disclosure standard and regulation of takeovers and mergers. SEE market. Under the new framework for listing, corporations that wish to list on the SEE market are required to appoint sponsors to assess the quality and suitability of the applicants for listing. The assessment would entail looking at the prospect of the applicant's business, its corporate governance record, past corporate conduct of directors, whether the applicant have sufficient system, controls, and resources to comply with the SEE market listing requirements, and last, ensuring the admission of the applicants does not undermine public interest. Transfer of listing from the SEE market to the main market of Bursa Malaysia Securities Berhad. A company which is listed on the SEE market may seek a transfer of listing to the main market if it fulfills any one of the following requirements. First, has interrupted profit of 3 to 5 full financial years based on audited financial statements prior to submission to the SE, with an aggregate after-tax profit of at least Rm 20 million and after-tax profit for the most recent financial years of at least Rm 6 million. Secondly, market capitalization of at least 500 million. And lastly, infrastructure project operation test as per the equity guideline.
Point 4. The advisor. When a company plans to flood its shares through a listing on the Bursa Malaysia Securities in Berhad or raise funds by issuing offering securities, it must appoint a principal advisor to manage the flotation exercise, prepare and submit the corporate proposal, act as underwriter for the securities offered, as well as act placement agent for any placement of securities. Applicant company relies on other advisors, including public, accounting, and law firms to provide professional advice. These advisors have a professional responsibility to certify themselves and, based on all available information, ensure that the application is suitable for the specific proposal being submitted for the Security Commission. A person who is found guilty of submitting to the Security Commission any statement of information that is false or misleading shall be liable to a fine not exceeding 3 million ringgit or 2 imprisonment for a term not exceeding 10 years or both. Participating organization is responsible for all the business activities as an advisor. The advisory operation shall be headed by a person which is approved and recognized by the Security Commission. This is important for the participating organization acting as an advisor to have in place and enforce written internal guidelines on the advisory activities so as to ensure avoidance of any conflict of interest and maintenance of a Chinese wall. 1.5. Preparing the prospectus. Prospectus is a legal document by which a company to sell its securities to public include a notice, circular, and advertisement. The content must comply with the provisions set out in Section 235 and 236 of the CMSA as well as the prospectus guidelines. As a general disclosure case, issuers are required to include such information as investors and their professional advisors will reasonably require and reasonably expect to find in the prospectus for the purpose of making as informed investment decision. The registration of the prospectus with the Security Commission must be submitted together with the relevant documents as set out in Section 233 of CMSA as well as the prospectus guidelines. In accordance of Section 234 of the CMSA, an issuer must lodge a copy of the prospectus to be registered with the Security Commission and a copy of the form of application accompanying such prospectus with the Companies Commission of Malaysia. As for the prospectus in relation to unit trusts or prescribed investment schemes, a copy of the prospectus and the form of application must be lodged with the Security Commission. Both of these actions must be done before the date of issue of the prospectus. Failure to comply with the requirement of the CMSA may give rise to criminal liability, civil liability, or both. A misstatement in the prospectus may lead to criminal liability under Section 246 of the CMSA. Any person who contravenes Section 246 shall be guilty of an offence and shall, upon conviction, be punished with a fine not exceeding 3 million ringgit or imprisonment for a term not exceeding 10 years or both. CMSA also may impose civil liabilities and in any certain prohibitions, including the situation where any person acts in a manner that is misleading or deceive, as provided under Section 246 of the CMSA. Section 357 of the CMSA provides that a civil proceeding may be initiated against any person who acts in breach of the CMSA. CMSA under Section 241 prohibits the publishing of any notice that offers or issues invitation to subscribe or purchase securities. Included within Section 241 are notices that refer directly or indirectly to a prospectus, an offer or intended offer, invitation or intended invitation, another notice that refers to a prospectus. 1.6 Completion of the issues and listing. A company intending to issue, circulate, or distribute a prospectus pursuant to an issue or offer of securities must file a final copy of the prospectus with Bursa Malaysia Securities Berhad and must register the prospectus with the CCM. A final draft of this prospectus must be submitted to the SC before its registration with the CCM. After registration of the prospectus, it is issued together with the application form to subscribe for the securities being offered or issued. Applications have to be made together with payment for securities before the closing date of the applications. If the issue is oversubscribed, a ballot is held to determine the successful applicants. If the issue is undersubscribed, the offering of securities must be terminated and all considerations received must be immediately returned to all subscribers. In the event that an underwriting arrangement is in place, appointed underwriter and sub-underwriter will be called upon to subscribe for the shortfall pro rata to their commitments. Company then advised Bursa Malaysia Securities Berhad of the result of the issue. Bursa Malaysia Securities Berhad grants quotation of the securities to market days after receipt of confirmation from Bursa Malaysia Depository Sdn Berhad that the securities accounts of the successful applicants have been duly credited.
2.1 Corporate Disclosure Policy. Bursa Malaysia Securities Berhad has adopted the following specific policies concerning disclosure. 1. Policy in immediate public disclosure of material information. A listed company is required to make immediate public disclosure of all material information about its affairs except in exceptional circumstances. 2. Policy through public dissemination. A listed company is required to release material information in a manner designed to achieve its widest possible public dissemination. 3. Policy on clarification or confirmation of rumors and reports. Whenever listed company becomes aware of true or false rumors and reports that can possibly have an effect on trading of security and decision, the company is required to clarify the rumors and report public as soon as possible. 4. Policy on response to unusual market action. Whenever unusual market action takes place in listed company's security, the company is expected to first, make an inquiry to determine conditions require corrective actions and take appropriate action. 5. Policy on unwarranted promotional disclosure. A listed company should refrain the unnecessary promotional disclosure activity to enable public to make informed investment decisions. Lastly, policy on insider trading. Insiders should not trade on the basis of material information which is not known in the investing public. 2.2 Continuing Disclosure Obligation. The continuing disclosure obligations are contained in Chapter 9 of the listing required of Bursa Malaysia Securities Berhad, which provide of the following. First, immediate announcement to be made to Bursa Malaysia Securities Berhad for release, including information to avoid the establishment of a false market, fixing a book closing date, declaration of dividend, notice of meeting, changes in management, proposed alteration of memorandum or articles, notice of substantial shareholding or changes, and application for winding up. Second, financial statement to be provided to Bursa Malaysia Securities Berhad quarterly within 2 months from the end of every financial quarter, giving all information prescribed by Bursa Malaysia Securities Berhad. Third, audit annual account to be issued within 4 months of the end of financial years, giving all information prescribed by Bursa Malaysia Securities Berhad. And lastly, annual report to be received by shareholder within 6 months of the end of the financial years.
1. Capital raising securities. As the companies are listed in the Bursa Malaysia Securities Berhad, there are numerous alternative for capital raising opportunities, including offering further ordinary shares or other type of securities such as debt securities, warrants, or other convertible securities. 3.2 Modes of issuing securities. The first mode of issuing security is by public issue, where it is an issue of new shares for sale to the public at a price agreed upon by the issuer and its principal advisor. The next mode of issuing security is by right issue. It is an issue of new share to existing shareholder for cash, generally at an attractive price, usually at discount to the current pre-announcement market price of a company's quoted share. It must be renounceable, which means that the shareholder may either take up the new shares offered or sell the right in parts or wholly to the third party or Bursa Malaysia Securities Berhad. All right issue for which there are no irrevocable written undertaking from the shareholder to take up therefore entitlement must be underwritten. The term of issue will be specified following the announcement of right issue. The third mode of issuing security is the private placement. It is an issue of securities that are not offered to general public, but are placed in the hands of party or parties that are independent and not under the control or influence of any of the issuer's shareholder or substantial directors. It is priced based on weighted average market price of the share for the past 5 days. The next mode of issuing security is by the issue of convertible securities. It is an issue of warrants or convertible securities may be made up by either way of right or otherwise. For an issue of structured warrants where settlement is by way of physical delivery and the underlying financial instrument is shares or an exchange-traded fund listed on Bursa Malaysia Securities Berhad, the aggregated outstanding collateralized or non-collateralized structured warrant issued at any one time must not exceed 20% of the share capital of the underlying corporation or the exchange-traded fund. This type of issuing security is an issue of shares from conversion of warrants and convertibles. This is an additional issue of shares to holder or other classes of securities such as warrant and convertible securities upon exercise or conversion of securities held. When they are issued, warrants are usually bundled together with debt securities, particularly bond. A warrant holder is entitled to buy a proportionate amount of shares of the issuing company within a specified period at a predetermined price. Convertible securities, on the other hand, are a form of deferred equity. The issuing company is able to raise funds at the point of its issue, whereas the holder of the convertible loan is entitled to convert them into shares of the company within a specific period at a predetermined price. Warrants and convertible securities are generally issued by public listed company embarking on project. 3.3 Debt securities and derivative product. In addition of equity securities, debt or loan securities and derivative product are also traded in the stock market. Also called loan security, debt securities listed on Bursa Malaysia Securities Berhad have a fixed interest rate and specific maturity dates. Hence, everything is fixed except for the market value, which fluctuates in accordance with the general level of interest rate in the economy. There are two main types of debt security, which are bonds and bonds. It is also referred as fixed interest or fixed income securities. It is a form of long-term debt issued by the government and companies. It guarantees the amount borrowed from the borrower will be repaid on a specific date, and a fixed rate of interest will be paid at a regular intervals for the period of the loan. For debenture, it is usually issued by large company as they offer a balance of security and attractive interest rate. It is usually listed at a fixed rate of interest for a fixed period. Debentures is a relatively low-risk investment and are secured by charge over the asset of the companies. Another way in which the company can raise money is by issuing debt securities, which can be converted into shares and are known as hybrid securities. One of the examples of the hybrid securities in Bursa Malaysia Securities Berhad is the convertible loan stock, while the example for a derivative product is called convertible loan stock. Loan stock are securities issued by a company for a loan made by investor. Convertible loan stock can be converted